This
to call to
conference
order
will
the
now be recorded.
Ocean Ridge Planning Zoning Commission meeting for Monday, March 20th, 2023. Can you call the roll, please?
Member Hutchins,
Here.
Vice Chair Carey,
Present.
Chair Marsh,
Here.
and members Rodriguez, Hennigan, Kaczynski, and Brenner have all been notified.
Yeah, so we're very skinny this morning. Can we all rise and say the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. At this time, I'll ask if there are any public comment from anybody. Seeing none, we'll move on. First item one on the agenda is a quasi judicial hearing. I've asked if any of the commission members have had any ex parte.
No, not.
No.
No.
And just a point of question, we don't have minutes from last month?
No.
Okay.
Okay, we're down one staff member from when I gather. Tara's having issues. So Corey, can I ask you just to give the commission a quick staff report? Oh, sorry. Thank you. Anybody that wishes to speak, please stand and be sworn.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, when you're called forward, please state your name and address clearly for the record and whether or not you've been sworn in, and please speak directly into the microphone.
Thank you.
Mr. Chairman, board members, Corey O'Gorman, town planner. This is the development plan review for 4 Osprey Court. That's the renovation and addition to an existing single-family home. A recommendation from staff is approval with conditions. There are several conditions from my report, primarily to clean up some data calculations, calculating the artificial turf square footage, the lot area, the floor area ratio, and a comment regarding the setback for the generator. And in that case, I believe they've made best efforts to move the generator to the 10-foot setback, short just a little bit. The town engineer has provided a recommendation for approval, also with conditions primarily regarding obtaining permits from health department and for water and sewer service, or for water service rather. And we'd be happy to answer any questions if we can.
Thank you. If the commission has any questions on engineering, it seems like they complied.
Yes, sir. I spoke with the town engineer this morning, and the project complies with the drainage requirements of the town.
Okay, thanks. Okay, who's presenting? Please come up and state your name directly.
Yes, my name is Mark Resmola with Z Construction. Would it be all right if Corey and I went over the questions at hand? Would that be okay with you? Take them one at a time.
Just give us an overview of what you're proposing, because we know it's an existing residence.
It is an existing residence, so do you want me to break it up to interior and
Who
exterior?
are you representing?
Z Construction and the homeowner.
Okay, so you are representing.
Yes.
Thanks.
Do you want me to do it by interior and exterior?
Just give us an overall background or description of what you're proposing, and then we'll address issues.
What we are proposing to do is we're adding a single car garage and a gym on the right side of the property. We're adding an outdoor shower on the left that's off to the master suite. We are proposing to demo the pool and add a new pool at the same location. We are adding a trellis when you come through the front door just to the left of the guest house. We are renovating an existing bar. We are renovating the entry. Am I going too fast?
No, that's fine.
Replace existing, all the windows and doors will be replaced, bring them up to new code. We will be repainting the dwelling. We will repair any damaged roof, truss and fascia. We will add a new roof to the whole house. And we will repave the existing driveway with a new layout. On the inside, we are reconfiguring the master bedroom and bath and living room, dining room and family room. We are reconfiguring the existing non-bearing petitions. We are reconfiguring all the bathrooms, adding new plumbing fixtures. So that is an overall on the renovation.
Okay, the architect isn't here, right?
Not yet, but I might be able to answer a question.
Okay.
on this.
No, I just for the record.
I think it was traffic and raining.
Yeah, bring the rain on.
Yeah, right. You ain't kidding.
All right, let's deal with the architecture first. Are there any comments?
I could have a comment. I could maybe help out. One of the, and I have a different number, but I'm gonna jump around. One of the questions was, the survey showed a 27,152 overall square footage. And the plan had showed a 25,170. And the city was asking to make them the same. But there was an additional question that we would take an easement into our calculation. The reason why that number is lower is that's already backed out. So that kind of two birds with one stone. So that kind of negates two questions that were on 5 stipulations, which brings us down to 3 questions. Does that make sense? And we could clarify the plan to show that a little clearer from what we have.
No, that helps.
I just found out. I was delighted. I can keep helping out. So the other thing was the generator, obviously, where we had 9.5 and we wanted 10. But I believe that Corey had said that we're okay where we are now. Is that correct?
Mr. Chairman, the code says that the accessory structure setback is required to be met for generators. However, where exactly the language, but where it's not, where the 10-foot setback in this case cannot be reasonably achieved, 5 foot is acceptable. And I know that at least what I have applied on development plan reviews in the past is 10 feet for new construction. And if it's an existing home, that 5 feet is acceptable. And I know you all have seen some of those come before you. In this particular case, it's an existing home with an addition, and the addition is what is pushing the generator out a bit. I think they certainly have made reasonable efforts, made best efforts to meet that 10 foot, and they're very close to the 10 foot. I'd say it's certainly up to your all's discretion if y'all like to approve it with the 9.5. But I think they certainly have met the intent of the code, at least in my opinion.
Thank you, Corey.
Thank you, Corey. Could you show us the site plan where the generator is relative to?
101.
Keep going, yeah.
Okay.
All right, you're in good shape right now. So, you want me to try to point, or you want me to come behind you?
No, it's fine. Kelly, can you just note it, maybe?
So you see that car that's in the driveway all the way to the right, and then behind that, it looks like a golf cart? That generator is to the right of the property, to the right of that golf cart, inside that smaller garage. And it's behind a concrete enclosure.
And the reason for it, if I'm looking at it correctly, it can't go, there's not enough property on the interior?
On the exterior, yeah, we couldn't, it's really the exterior. Look, see, we're on the property line on the right side to where we are, right there.
Right.
We just can't go further out or in.
In, okay. Okay,
6 inches.
all right, well, we have that up. Can you, and Corey help the commission here on the issue of the synthetic turf and the percentage. Is that located just in the pool courtyard area or?
Mr. Chairman, yes, the site plan just shows the artificial turf. If you can see the blue image in the pool, it's to the upper left and sort of wrapping around to the upper portion and to the left of the swimming pool. The calculation issue that I pointed out in the staff report was that, at least on the data calculations, it showed the artificial turf calculation based on the total lot area, where the code talks about the calculation being the net side and rear lot area less the building pad itself. So just running some rough calculations, I think they're fine. I just would like the calculation to be shown correctly.
We are gonna have to get the architect to redo that for
Okay.
exact.
Yeah, we
We
need
can't
that,
just shoot, we just can't.
that needs to comply.
We definitely have so much land and so little house, but let's get those exact numbers down.
Yeah, pretty large house. It's a big property, I admit. Okay, while we're in the landscaping, one thing I'd like to recommend to the commission, we approve or ask the applicant to do is to plant a hedge on the west side of the existing wall that's on the right of way. This is our normal requirement now. If you're face the right of way that with a wall, you have to plant a hedge on the outside. And I noticed that there was no indication of that here.
Could we bring up the landscape plan?
On this side.
Do you know what that is? Thank you.
See a lot of clouds around it. I don't see-
Well, let's hope it changes, right? Sorry about that.
Which
It's L2.
L2? I'm up near the front.
You know where I'm talking about?
Yeah.
On the street side.
Didn't
Yeah.
there used to be something there?
No, that would be. Do we have a answer to that question?
So, we're talking on the backside facing A1A?
Correct.
Okay.
So there's a requirement for any wall along the right of way to have a hedge. I don't know, I can't recall what the height is, but
It's pretty stark right now.
yeah, this is one of the main interests of the town, so that would be a condition. The roof material, what is that proposed?
Flat tile?
Is the roof being changed? You said something about repair, but the existing roof's not being
I
changed?
did say we're changing the roof tile.
Oh,
We are putting the new roof on.
okay.
Not, the pitch stays the same, right?
No, we're not changing any pitches we'll just replace, either rotted fascia or rotted plywood.
Thank you.
It currently has a barrel tile, right? And you're going to go to a flat tile?
Yes,
Okay.
correct.
Excuse my, try to see here, but where is that tile shown?
I think they want an exact tile now.
It's, I mean.
No, right just there.
Can I ask a question to staff? Do we have a requirement to have a planting along a situation like that, or is just what we think is best practice?
There you go, there's the tile.
There is a code requirement for landscaping between walls and the right of way. Yes, sir.
Thank you.
Yeah, so there is, Carlos, can you just be sworn in?
Yes, good morning. My name is Carlos
For you. You raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Just state your name, please.
Good morning. My name is Carlos Leonardes with Randall Stock Architects.
So what color are the roof tiles?
It is supposed to be a charcoal gray with Boro is the company name that we've selected.
And the color of the house is going to be?
It's going to be a light white, dove white. It's
sample. That's it.
Yeah, that's fine.
It's not the house.
But you, as part of the requirement, you should be giving the actual sample.
The exact samples, we could definitely bring that.
Just for the record.
Absolutely.
All right. I think it's, David, you got any comments?
No, not really.
Rick?
A couple questions for Corey. So this is, there seemed to be some question about the FAR on this. Is the FAR as drawn meets with our requirements currently?
Yes, sir, it does.
Okay.
And what was just pointed out a few moments ago is that the square footage of the lot that's shown in the data calculations is actually the net land area, which I wasn't aware of. And I don't think 90% you weren't aware of it either.
Exactly.
So what I was asking was that since the FAR is a calculation that is usable land area, the usable land area, at least in my opinion, in this case, would not include the access, drainage, and utility easement, because that provides access to the entire subdivision and is dedicated to the HOA for their use. What I also noted was that there was a discrepancy between the square footage that was shown on the survey and the square footage that was shown in the data calculations. Well, it turns out that discrepancy is that they had already netted out that easement area. So if the FAR is a calculation based on the net lot area less the easement, it's complying with that condition that's in my report.
Thank you.
You're very welcome.
Okay, no, I think that house has looked pretty tired for many years, so glad somebody's gonna improve it, so this should be a huge improvement. As I said, the hedge was my main concern.
We'll add that. Do you do that? That's in the easement in the back. So we'll get a letter from FPL or whoever it is so that we can add that edge. That's
Yeah.
why we didn't have it on there, because that was not our property.
Yeah, as long as it's a hedge. Yeah, I asked.
You have it
They
on
always give
either
us
side
those
of this
letters.
property currently. If you just look what's there
Yeah.
and continue it, close the gap.
No,
It's not something that's going to be denied by the utility company.
exactly.
So you might want to ask the town staff what the requirements are.
We've already done that. We know, we've done it with other properties, so we know what to do.
So, yeah, I think it's kind of revitalizing an old project, so good job.
Thank you.
We ready for a motion?
Yes, sir.
Can I comment, please?
Sir, sure.
Terry Brown, Harvard Art South. I'm glad that you brought up the wall facing A1A. I know you're always a couple of steps at least ahead of me. But is it going to be a wooden fence or a wall? If it's a wall, it has to go back 3 feet from the property line. What's going to be built there at the end when the construction is finished?
It's an existing wall, I think.
It's an existing CBS wall.
It is, okay.
We're not adding.
And it's going to remain.
Correct.
So the other question is that FDOT has up to the wall, or are you 3 feet from their line? You can get landscaping approval for that wall so that it can be masked from the roadway. Instead of just putting a hedge up on the other side, you're gonna put a hedge on the wall side. I mean, the A1A side.
That's what we're asking.
But you could do more landscaping if you get their permission to put in a couple of native trees, for instance, or shrubs, something that will offset the property from the road. Am I making sense?
You're making sense, that's something else.
Yeah,
Okay.
because it's pretty horrible looking now, and I know it's gonna look a lot better. It's gonna look bigger, but it's gonna look better, what they're doing to it. So that's a good thing.
I think, no, I think the hedge, you don't want to encourage planting, in the
Well,
right of way.
the state put landscaping on the other side, if you notice, and the power lines are on the west side of the road, not on the east side. So you can get permission from them to put something there.
I think the hedge would be a huge improvement.
Otherwise, we're all gonna be looking at it for years.
No, I've been looking
We'd
at
like
it
to
for 40
see-
years, so.
We'd like to see a hedge that makes the wall disappear and hopefully for the house purpose and our purpose to have that. Are you sworn in?
Yes.
Sir.
Okay.
I was sworn in. My name is Dwayne Dickerson. I'm an attorney with the law firm Dene Miskel and Backman. Offices at 14 Southeast 4th Street in Boca Raton. And like I said, I have been sworn in. I just want to state for the record, as a lawyer, that what you're saying makes perfect sense. I just would like the condition to be subject to getting the approval from whoever has jurisdictional authority over that area. So if it's FDOT or any utility, I just don't want to represent that we can do something if the underlying jurisdictional authority says no. But we're gonna ask, it sounds like we've done it before, and we shouldn't have any issues whatsoever. But that would be the only thing that would stop us, is if the jurisdictional authority, for whatever reason, would not allow us. Does that make sense?
You checked in. Good.
Yeah, yes, sir. Thank you.
Okay. Okay, so a motion.
I'd like to make a motion for approval, subject to all the conditions listed in the staff report and the additional condition of a hedge being planted on the west side of the wall along A1A in compliance with all jurisdictional requirements.
Second.
All in favor?
Aye.
Aye. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Good explanation.
Thank you. Sorry to get that.
Okay. Okay, we do have a second item. Second item that was added to the agenda, I guess. Christie, can you help me? This is on the surcharge. Surtax.
That separately, right?
Okay, okay.
Another item on the agenda.
Have I got the wrong agenda?
Looking.
Somebody help me here.
I think we're
'cause-
going back to the Anna Street.
Did I miss that one? I apologize.
It's,
It was a late comer, right?
yeah, it
Kelly,
was the
can you help me
request,
here?
that-
'Cause
but I don't see it. It was in the distributed package, but I don't see it in what I picked up.
Today's back.
But I know what it is. It's the,
Kelly, can you read whatever the second item is? Because for some reason, I know you sent it out. I think I saw something, but
It's section of the proposed code amendment to 64-1 RSE districts.
okay. All right. So Christie, can you help me here?
Yes. So, Mr. Chair, as you may recall, at the Town Commission March meeting, when the Planning and Zoning Commission presented their report, the recommendation from the February Planning and Zoning Commission meeting was to deny the proposed text amendment that was proposed by Mr. Pappas for his property at 6073 Old Ocean. As you may recall, that was the text amendment to address Mr. Pappas' property and the other parcels that are along the east side of Old Ocean between Anna and Corinne. The town commission then directed Planning and Zoning Commission to come back to this meeting and further discuss that proposed text amendment to determine what this commission would deem acceptable of that proposed text amendment. and then make a recommendation back to the town commission, who is going to, as of now, hear the text amendment on first reading at its April meeting.
Okay, we all understand.
One of the challenges I think here is that the proposal is not, although brought forward by the property owners and the attorney of 6073 Old Ocean Avenue, they're including 2, 4, 6, 8 properties in there. I don't even know if the other property owners are aware or have stated their interest, but this one size fits all approach to this is very difficult because these lots vary in size from a width of 105 to 55 feet. So I think it's nearly impossible to come up with a suitable solution that would cover all these properties. Now, there's a possibility of doing an overlay that would still leave some of the properties out of compliance. I know that that's not ideal either. I believe I'm speaking for myself, but I think I'm speaking for my colleagues here too, that we're sympathetic to this one property owner's desire to get approval for their property. What latitude do we have in specifically reviewing 6073? This is a question for the attorney. If they come in with an application that doesn't meet all of our setbacks and other requirements, does this board have the authority to move that forward and approve it, even though it's not in full compliance?
Mr. Chair, in response to that, if you may recall, when the development of Mr. Papa's property was first presented to the town, it was presented as to come before this board for development review. The problem is that they needed 5 variances from the code in order to come before this board to be in basic compliance with the code. So they initially went to the Board of Adjustment with the request for 5 variances. Those variances were denied, with 2 of the variances denied without prejudice, meaning they could come back on those 2 variances. Those 2 variants were the total lot size and the lot width, which most of the properties in this area between Anna and Corinne suffer from those 2 issues because it's all zoned residential estates, and the requirements for total lot size and total lot width are much larger than most of these properties can satisfy. So the Board of Adjustment recognized that they have a hardship because their lot size, even though it's not a legal lot of record, it's smaller than what's required for that zoned area. The other request that they had for variance dealt with one of the issues that is also problematic for the properties on the east side of Old Ocean in this area, is from the Coastal Construction Control Line, the amendment in 2020, which restricted the usable area for anything beyond the 79 Coastal Construction Control Line. So for Mr. Papa's properties and most of the properties there, it really cut their usable lot in half. And as Mr. Gorman said in the previous application, when you're determining FAR, you don't look, according to the definitions in our code, at total lot size, you look at usable lot area. So it created a problem to squeeze, now it's even further squeezed. So, looking at this issue, talking with the attorney for Mr. Papa's, we were really concerned with the Coastal Construction Control Line because a lot of cities have adopted the 79 as the line. And how do we address this? And one of the things was, right now in the code, there is an overlay for any lot that is 7,500 square feet or less. So under that overlay, it would allow Mr. Papa's right now to redevelop if he got the 2 variances from total lot size and total lot width, but it would limit him to a 2,700 square foot home. So, unfortunately for Mr. Papa's, he bought the property after the 2020 change was done. So he kind of bought it taking that, as is. But it is an area where I think there's some recognition that these folks have a hardship. It's an area that, is problematic because we believe at one point all of these lots were unified. So at some point, the RSE zoning district made sense, but once they were all separated, now the RSE district, makes it impossible for any of these to develop unless they get some type of variance. Right now, the Board of Adjustment has on its agenda for its next meeting a property across the street from this that also needs a variance for total lot size and lot width because it doesn't satisfy those requirements.
Yeah, the RSE, it doesn't seem to be a good fit for these, but the RSF wouldn't solve the problem either. So my question is more fundamental about jurisdictional Board of Adjustment versus here. In this approval we just made, we agreed to allow them to put a generator 9.5 feet from the property line, even though the code says 10 feet. So we apparently have some latitude here. How much latitude do we have? What I'm trying to do is see if it's possible to save these people from having to go to Board of Adjustment again, if they came with the application that was basically compliant with the 2 variances that it appears the Board of Adjustment would grant, but save them going through that process, the expense of it, and come straight here. Is that possible, or does it still need to go to Board of
I think
Adjustment?
the possibility for doing that is what they've explored now is to actually do a text amendment. Because there's no latitude for this board to grant a variance from lot size and lot width because there's no language in the code that gives this board that kind of authority. And there's no language in the code that allows for, like with the generator, something different than what's required.
And for them to reapply to Board of Adjustment, is there a new application, or can that be waived and they because they've already previously paid to go before Board of Adjustment? Because it's fairly expensive, $1,500, is that right?
That's correct. They would have to
Can
pay.
I think there's a fundamental problem. Excuse me. Board of Adjustments and the Town Commission were established before this commission was created. I mean, it was always a Planning and Zoning Commission, but they were very unused and not very technical in their review. Most towns, and I've said this over, this board is what reviews planning and zoning criteria as to the ordinances, the requirements, and then in all towns that I know of, and I do this for a living, is this board would make a recommendation to the Board of Adjustment based on the fact that they see that things are difficult, hardships, and then the Board of Adjustment at least will have some fundamental reference by which to make a judgment. This case was just blasted through the system. In fact, the drawings were complete before any of this happened, which is what made it so unusual. And
Yet it never found its way to us. So
no, I mean,
I never heard about it until it showed up as a overlay.
bypassed everything. Again, I'll just give for whoever wants to listen that in the town of Palm Beach, which grants at least 10 variances a month, if you're familiar with Palm Beach, there's called C Block, Sea Breeze, Sea Spray, and Seaview. And they're all small lots that have been granted because of the hardships, as this property has. Single applicant instead of going to a blanket, because as I said the last time, not all these properties, 8 properties, the geometry or the topography is not the same. So it's not a one solution for everybody. But I think, I understand, believe me, I deal with the coastal control line, construction line. And in this case, it's unfair on those owners to take that much property for development. And the reason here is because to help, a new seawall has been put in, which is what DEP's job was, to protect people on the coast. The seawall is there as a barrier now, a constructed barrier, which wasn't there before. And it's a random line that runs through from Martin County to Monroe County. And it's not going to, one size doesn't fit everybody. But what I took objection to was the way this process was done. And the fact that we're now trying to solve a problem that the owners experience. And I think it's unfair. Why I call it egregious is because the amount of development they want to put on the property is way over, even through a reasonable granting of a variance or hardships. And so it's like taking this one and changing everybody's, it's backwards. And that's where my objection stands. I do this, as I say, regularly.
Can I?
And it's,
After you're done.
and I think the hardship is definitely the old 79 coastal control line. In fact, DEP doesn't mind if you're built up to the seawall. Technically, you'll get a DEP, permit. But the town has adopted this ordinance, and I think case by case, it can be presented by an owner as to the hardships and why they need to have relief for, certain things. And I'm just fearful of having an overlay that just blankets everybody. And I know that the, I don't want to say sales thing was, you're not going to be able to develop on your property, which is technically correct, but incorrect, that if you're doing it in the correct manner, I'm sure any reasonable commission, board of adjustments, or whoever would support that. But you can't just have one size fits everybody. It's not that. That's not how zoning works.
Not as varied as these lots are.
Yeah, so let me,
Sure.
because this is where I was trying to see what we could do. We have residential estate, we had residential family. These lots are smaller than the smallest recognized lot for residential family. Why not think about creating a special, something different, residential overlook, and create some boundaries that would allow the development of a nice home, not a monstrosity, in that area, because we're talking about small lots. You could still put a nice home on a small lot.
Sure.
Yeah.
And,
Nobody's.
well,
And that's what we'd like to see
that I
done.
liked about what this fella did was he had a good setback from old A1A, the Anna Street extension, and he was, I think, planning to build right up to the CCL, correct?
I've never seen the drawings, to be honest.
I thought that was his proposal. So say allowing for that, if we created setbacks on the side, setbacks from the street, and a limitation on that line, it would be different than anything we have, but we could just create a new.
Yeah, but the difficulty is that when it was presented to us the last time, the request for changing, we're going from like 32% floor area ratio to 82%. Now that's just abnormally high. I mean, you can be a layperson and hopefully see, that what the result will be. You're almost 3 times the size of what you're allowed.
We
So-
have existing places on there that have a pretty high.
Yeah, I agree, but that was developed as part of an estate potential in the past. Joe is a good one.
I
So-
think nobody wants to bar the redevelopment of any of these lots if they need to be
Absolutely
done. But if they were all the same size and same general dimension as they are most everywhere else in the town, even in the, the Ocean View overlay, the lots are relatively the same size. They're just smaller. Here you have a situation, if you granted the 50-foot lot width that was proposed, you'd have 2 lots here that could be divided into 2. It could be split because they, and probably would be at some point. So
But that, they would have to apply for that, right? They'd have to
if you
come up
agree-
and-
if it's allowable, we've done it over here on Ocean to a couple of lots that when they, if they meet the minimum requirements, it could be split. So,
And we've also allowed 2 lots to be combined, right?
right,
Yeah,
and
so,
that's fine.
oh, yeah.
So
It's all possible.
the-
It's all
the
about land
difficult-
area.
The difficulty, Dave, is that these are not similar. There's a big variability. So it would be much better to address the needs of each property individually. There,
Which would still allow for the property to be built right up to the edge of the existing street. And,
What?
right?
You have a front setback. No, you can't, you can grandfather where you are,
Right.
but you can't, without a variance, you can't build to a 0 lot line or whatever you're, referring to.
But somebody could build on that existing
Footprint,
footprint,
correct.
right up to the street.
Why are you saying right up to the street? I don't.
Well, the number of homes, including the one we looked at,
Yeah,
Extend right
you
up.
have a grandfather criteria by which you can, use to, secure your point of reference.
but if you're gonna,
But that
knock
goes
it
all
off.
through variances and, those are normal zoning requests. But
So,
once you remove that, you've given up your grandfather.
so the applicant does not want to go back before for the variances, or when you're
No,
talking to their attorney?
correct, they are, they proposed the text amendment, which is what you looked at your last meeting, and that's going before the town commission at the April meeting. What it sounds like, because, Mr. Chair, my experience at other municipalities is not like at Palm Beach. And if you go to planning, you go to the Board of Adjustment first to get your variance, and if you get those, then you can move forward to planning and zoning. But my question is if the town were to consider revising the process for the properties in this area to allow applicants to come to this board first to perhaps figure out what this board felt were acceptable variances and acceptable development, and then that process would then go to Board of Adjustment for their review based on your recommendation, then is that process like in Palm Beach, with that process, then is the Board of Adjustment the final say?
No, town commission
Then it goes to town commission
on their recommendation.
on their recommendation, and the town commission makes the final determination.
Sure.
Is that what you would propose for the properties in this area on both the east and west side of Old Ocean?
I think, as Mr. Kira just mentioned, I would like to see or suggest that each individual lot comes in separately instead of a blanket, because it just won't work for some of these property owners
Right.
under a global thing. And as I said the last meeting, that's a precedent, I think, that if we set in the town, it's going to create issues down the road for when we're long gone, David, don't worry.
yeah, that's soon enough.
But I like what Christie's suggesting here. It would be
I do too.
to take this unique area
Sure.
and Shane, and have the process kind of flipped for these properties.
Yeah, no.
And that would give them an opportunity to, because it's more iterative with us and with the town staff. You can kind of go back and forth and kind of massage it to where you get something that everybody can live with. And then we've defined what variances that we would propose would go to for variance.
Yeah, I think, and I don't want anybody to misunderstand, we're not trying to be unreasonable. It's just the process that is proposed now has flaws.
Yeah.
And I just don't think, we want to provide the owner the ability to use his property, but. So yeah, I'd suggest that. Well, what I'd like to do is make a motion to ask the town council to postpone. I will not be here on the 3rd of April. It doesn't matter, but that's not the reason. But I think we need to have more discussion on this. So I'd like.
I'll second that motion. It's a question, is there any time requirements with this text amendment pending that they can't extend it beyond that date?
Under the code, it has to go before the town commission within 60 days of your hearing it. So we're within that time frame. The town commission could certainly defer its decision on first reading or its decision on second reading to afford this, commission more time to review the matter. And what I would suggest is I can work with Mr. Gorman, and we can look at Palm Beach's code and maybe suggest a process that could be adapted just for this area.
Mr. Chair,
Yes.
if appropriate, may I speak? Thank you so much. Once again, Dwayne Dickerson, for the record, attorney with law firm Dene Miskel & Backman, offices at 14 Southeast 4th Street in Boca Raton. And we do represent the property owner, Mr. Pappas, at 6073 Old Ocean. Couple of things. I know this is complicated. We wish it was easier, but there's a lot of moving parts here. I wanted to approach, if I may, Mr. Chair, and hand you a very user-friendly spreadsheet that kind of shows the 8 properties and what the existing square footages are, what they were permitted to build before the 2020 amendment, what the net lot area is afterwards, and what this proposed text amendment would allow them to build. And then also the last row is about that code section that the town attorney talked about, where if you're less than 7,500 square feet, you can have additional development rights and what that would look like. So may I approach?
Sure.
Thank you.
Thank you.
Yes, sir. Okay, sorry about that.
And one for you. You're welcome. So as I stated, you can see there are 8 homes that would be affected by the amendment. And on the left side are the addresses. And the next column is the existing home square footages today as they're built. The column after that is the pre-coastal construction control line code amendment, which was the 2020 amendment, and what was permitted before that amendment for maximum redevelopment potential. Then you'll see the net lot area size after the CCL amendment. And as you all stated, it took a significant chunk of the property. And then your FAR calculation requires you to now just use the remaining portion, not the portion, even though we still own the additional pieces of that lot. And then the next column shows you the proposed code amendment and what the maximum square footages would look like. And then what for maximum redevelopment. And the last one is that section 64-7 and what that looks like. So we can just take Mr. Pappas's property just for illustration purposes. So his home is just over 2,300 square feet now. What he was permitted to rebuild if there was a catastrophic issue with the house, he had to rebuild before the 2020 amendment was 5,300 square feet. And now his net lot area after that amendment was only 5,500 square feet, right? So what this amendment would allow for is a approximately 4,500 square foot home. And then with that overlay section, you can see it's really not effective. May I have 1 more minute, sir? See, I'm on the clock. The last column is about That's what that overlay would allow him to build, just over 2,400 square feet. So I understand, I went to law school to avoid math. The only class I liked was statistics, because you could make statistics sound really good. Like I could say, 100% of the people sitting at this podium right now are good-looking black young men, right? And that's 100%. And all right, that statistic sounds great if you say 100%, but it's only one person. So I'm just a facetious way of saying that I hope you can look at the other factors in addition to just the percentages, right? Because the ask is with this text amendment to have 65% total lot area, right? And 82% of finished floor area under roof. So I understand those are larger than what you have today, but if you look at these numbers and what it would allow for, I don't think it's over the top or anything that's egregious based on what they're asking for.
But I have a question, right? Go ahead,
Yes, sir.
you first.
Your second column, remember that pre-redevelopment, you could use to the high water mark.
Yes, sir.
So your pre-CCL code amendment is kind of skewing that second column. And I don't know how you arrived at those figures, but you could see that what you're referring to is, what you've lost is not really correct, because that was amended many years ago to not be able to use your area to the high water mark. It was then amended to the seawall, if you had a seawall, and then the CCCL.
Right.
So I just question the second column there.
Yeah, well, we've worked with our development staff. Obviously, we have engineers and architects way smarter than me. So, but I think the moral of the story is that what was permitted pre-amendment was significantly larger than what's permitted post-amendment. And I think we understand the intent of the amendment to protect the environment and the coastal construction control line area. But I do think there were some unintended consequences. And as discussed at length earlier, how do we handle this? I think your town attorney made a really good point. Well, in my experience, and I'm a little older than I look, these gray hairs, I have a few gray hairs now. What happens is if you consistently have to ask for variances, the municipality at some point says, okay, we need to revisit our code, right? And so that's why, it's always, do you want variance? That's the age-old question. Most property owners prefer variances because I get to prove my case on my own, and I don't have to worry about quote unquote Pandora's box, right? Because if it's a text amendment, theoretically it's citywide or townwide, right? Versus a variance, it's my own property, I prove my case, and I don't have to deal with other property owners. I think this is the perfect balance, and as you all know, there's one of my law partners is handling this, the majority of it, but so I've had the opportunity to consult with him and try to help him understand what we think is the right way to go. With this, it's very narrow in scope, right? It's only 8 homes that would be impacted by this text amendment, and I believe that that's the right way to do it. So typically a text amendment would be townwide, but this is not proposed to be that. It's very limited in scope. It's very limited in area. It's on the east side of the road of Old Ocean, and it only impacts 8 homes. And these numbers, and I agree with that. I think you can, smart people can debate, the measurements and so forth. But at the end of the day, I think the theory still holds that this amendment will allow for a reasonable development and allow for pergolas or pools or porch patios seaward of the line without structures, and that meets the intent of what I believe the town was wanting to do. And the last thing I'll say, and then I'm happy to answer any questions. The last thing I want to say is I think you all raised a very, very good point. There are 8 other homeowners. How do they feel about this? I know I represent Mr. Pappas, but I think it's important to understand what the other impacted parties, how they feel. So we were able, dated March 13th, to get a letter, since essentially a petition signed by a majority of the owners. There were a few, there's one owner that owns 2 homes, and there's one other owner, and it was difficult to get everybody, but we have a majority of the homeowners that very clearly state that they weren't aware of the code amendment and the impacts that it would have, and they fully support Mr. Pappas's application. So I'd like to share that with you if you don't mind.
Let's give it to,
Thank you.
go to the record.
So when you're back to the podium, I have a question for you.
Yes, sir.
So
I don't want you to be left out. He got one.
I can't read anyway, so it's okay.
you focus on the change to the coastal construction line
Yes, sir.
and how it impacted this particular property and the other properties along here. But that isn't what the text amendment addresses primarily. It talks about lot widths, it talks about FAR. So if the coastal construction line's at issue, why didn't you just bring us a text amendment about the coastal construction line? It looks like you've tried to take the opportunity to load up whatever you could on the truck since you were going to have an opportunity to drive the truck through this. And that I find offensive, frankly.
Yes, sir.
I agree.
Well, but that's a good point. It is my understanding that the amendment in 2020 significantly changed the development opportunities or the redevelopment opportunities for these homes if there was some catastrophic event that damaged the homes. So I think the request, and so whatever ancillary items or issues that came from that was what this text amendment is trying to repair. And I think some of those were unintended consequences. Right?
I have to feel, sorry to interrupt you here,
Sure, no.
that had this change not even happened, you'd still be before us today trying to get the other things changed.
Yes, I mean, I think it's a multiple request or a multiple issue request, so I think we all agree that, and I speak personally, but I'm sure my fellow commissioners here and absent accept the fact that there is a hardship by the use of this coastal control setback line as a setback. But as Commissioner Carey just said, I think any reasonable person would have seen that and said, yeah, let's help that person or people to address that. But this is a fully loaded, you came with 5 variances. And that's what kind of, turned the lights on.
I think Mr. Pappas probably wants to speak to that a little bit, but I'll tell you, that's another thing. We did go that variance route first, as you all stated, and that did not go our way. So therefore, the only other option would have been a text amendment to amend the code. I don't think it was. I know this has multiple parts to it, but at the end of the day, I think it's, what is a reasonable amount of redevelopment opportunity for these homes, and what is a reasonable amount of accessory uses of these homes, including pools, pergolas, and patios and so forth, consistent with, what we believe any beach community would allow. So I don't think that's.
Just before you speak, it's just, you're using the coastal construction line change as a red herring for other items. When you went for variances, you looked for other items beyond the coastal construction line. So if you took that out of the picture, are you willing to be compliant? That's,
I can help with that real quick. Todd Pappas, 6073 Old Ocean. Good morning. You're right. We're throwing a lot at this situation because basically all the properties are illegal, non-conforming. All of them need a variance to do pretty much anything if they were blown over. So we are looking for lot width. We are looking for lot size, basically a variance. And our goal was to put together this overlay that might have solved everyone's problem on the street so that year after year, they're not coming in for a new variance, for a new build or a burn or a hurricane. So we were trying to kind of get it all done in one full swoop for all 8 homeowners. And I believe we have 5 that we we've contacted that are all for it. And we have one that's on the market and really doesn't want to get involved. He's getting ready to sell. He's moved to Seattle, and 2 of the homes are owned by one individual. And I don't think that they, I don't know that they went before it. I just don't know that it really affects them because they're pretty new and they're pretty big. So I think, I'm looking to build a 38 to 4,000 square foot house, 38 under air. But we were trying to answer your question, we were trying to get it all done in one full swoop for everyone, so they're not burdened by individually coming in for these different things. So
Understood, but these are lots that are each one unique. And that's, if they all were the same dimension as your lot, the overlay could be a perfect solution.
yeah, most of them are, but there's a couple that are smaller and a couple that are larger.
The geometry. David,
You're right.
sorry.
I don't want you to think it was egregious that we were trying to shove it all in, but we were trying to solve the problem so that we could start the process. We've been working at this for
I
a
get
year.
it.
We did go to the Board of Adjustments. We were denied for lot width and lot size. And you've got my neighbor across the street that is trying to get the same thing done. We tried to keep a wall so that we could get 2 more cars off the street, which would benefit the street. We were denied on that. And so basically everybody said, well, you went in for too many variances. I said, well, what were we supposed to do? Going for 1 today and 1 tomorrow and 1 next month and burden the Board of Adjustments with variances? So it does solve all the problems, and maybe it doesn't solve them all exactly the same, but ultimately the last thing I'm going to say is that it makes this street better 10 years, 20 years, 30 years down the road, because it sets these homes back 25 feet and it opens up air, light, and allows people to walk. This is a very important street to Ocean Ridge. As I said before, it's the gem of Ocean Ridge. And it's crowded and it's tough, and people love to start at Anna and walk down Old Ocean, and sometimes they can't get by. So ultimately, getting all these homes set back 25 feet is a positive thing.
Okay, I want to be part of this rather than an observer. The attorney made something that I thought was a good idea, and that is the prospective builder or property owner meet first here to get a sense of things and maybe get some direction. After that, go for the variance. And what do you guys think about that? I think
That's
that
what
makes
we
some
tried
sense.
to do, by the way. We weren't allowed to do it.
No, sir, I have
Doesn't
to
do that.
correct something. Sorry, David. Your application came in full bore,
Right.
fully developed plans, assuming a lot of things. And then when you were told, these are violating the criteria, you had no option but to go to the variance. And that's what I said is wrong with the process, because you've committed a lot of money to develop something that you thought could be done, to find out it can't be done. And I think
In
That's
terms of my architect, he said Ocean Ridge is gonna love this. Because nobody knew about the 20.
I love Randall, and him and I go a long way.
Yeah.
But I think that was initially the problem. And what you're trying to do now through this application, currently, and the way it stands, is try to solve all the assumptions that you made early on. That's not how it works. You usually start out and find what restrictions, if you identified that the land area was an issue based on the coastal control line, that's a great starting point. I've done this.
I know.
So I
We
can
tried to come to you. We were told we can't.
No, well,
We
it's,
told you have to go to the
and
Board of
maybe
Adjustments.
David has just said, and the attorney has recommended, is that you come to us for support before you just come in. But what I find egregious is that this application was then tailored, you're trying to tailor it to solve your problem. And that's what I find very
Trying to
difficult.
solve everyone's problem.
No, it's your problem that you created, and you're now bringing in other people, which is fine. I think
You wanted support from the other
But
neighbors. So that's why I brought
I
it.
talked to this, I've done 5 of those properties, so I know, okay? And the fear that was put into them is concerning, but there, you have all the right to try to request what you want to do. It's just how it was done. And, you know, it was like a the gun was loaded full. Just,
Again, you're trying to get it done.
Sorry, David,
We
go
weren't
ahead.
looking to piecemeal it.
Yeah,
but
and
it's-
if I can say, really what you're doing for yourself, and I appreciate it. But to extend it out as a magnanimous act for your neighbors kind of is pushing. Just speak for yourself what you'd like to do, and maybe if we agree to it, you can get some advice from us and go to the variance route, if you guys think that's a good idea.
That's what I suggested.
Yeah.
I think that's. So, Christie, as I said, I'd like to keep the motion of postponing this, asking the town commission to postpone, because I think there's a resolution here somewhere, but it has to take time and go through some additional processes.
Okay, so if the vote on the motion is approved, then at the April Town Commission meeting, we'll certainly inform them the planning and zoning's recommendation is to defer. And if you're okay with it, I'll also express, the idea of flipping the process for these properties so that it's more of a sort of informal meeting with P and Z first to go over what they're prospectively pursuing and set some parameters and ultimately a recommendation to the Board of Adjustment, which then makes a recommendation to the Town Commission for final action.
I think that'd be really important.
Yeah.
Do we need to state that that's our direction and emotions? Does that make it better for you?
If either way, I, can certainly, tell that to them. I think what I would have to ask for is if they're willing to defer it, direction from them to go ahead and draft a proposed ordinance that would flip the process for this area and bring it back before you for your April meeting.
So we give this area special consideration.
Right.
It's a unique place in town. We all
Correct.
recognize that. And we're willing to have the process modified for these 8 properties.
Actually 9, right? The one across the street.
I think you probably need to look at most of the properties in this area.
Yeah.
For
Under the
that
RSC.
process.
So that'd be another reason to defer it, is because it could be encompassing more than the 8, as Dave points out. And there's probably some others, if, whoever's next door to the one across the street, and it's a unique block.
Yeah, we all
It's kind of
recognize
said
it.
from Corinne Street to Anna Street to A1A. It's a unique little spot in there.
So if you want to make it part of your motion, that we tell them the thoughts of perhaps a different way to address this, make it part of your motion, and I will inform them of that at the April
You just
meeting.
made it.
That gives them something,
Yeah.
that gives them something specific, not just, we want to
Yeah.
punt.
No, we have to look at it in detail.
Mr. Chair, if I may ask a question, that's appropriate.
Sure.
So and maybe this is through you to the town attorney. So I just want to be clear that if the motion would be that you flip the process, but the process to accomplish that motion would require an ordinance, which then would require, I believe, 1 reading or 1 public hearing by your commission, and then 2 readings by the town commission. Is that correct?
That's correct.
And then once that process takes place, then we would resubmit an application that would come to the Planning and Zoning Commission first to make a recommendation to the Board of Adjustment. And then the Board of Adjustment would make a recommendation to the town council. And the town council would be the final approval of whatever variance request. So it would not be a text amendment. It would be individual variance requests by each individual property
Property.
owner.
Correct.
That's well stated. I understand from where you stand, that sounds long.
But
But,
I'm just thinking.
I mean, we're trying to tailor something to meet both of our needs and the long-term needs for other properties in this area.
Yes, sir. I didn't know that I was gonna get a retirement plan. I could think that's at least 6 or 7 hearings. I probably can retire off of this project.
We're not here to obstruct, we just have to get.
Yeah, that, I know there's a balance and it's difficult, but as you can imagine, we've been at this process for a year plus. I know it's not just about us. I know the town has to do what's in the town's best interest. But like Mr. Papa said, one, we did submit variances, individual variances and, to Board of Adjustment, and that didn't go our way. And then we did request to come to the Planning and Zoning Commission, and we were told that was not an option at that time. So,
I mean, he also still has the option that there are 2 variances that there's a strong indication that the Board of Adjustments would approve, and he could move forward. So it's a decision based on the information before him.
and the other 2 more points. One is that the town commission will vote on whether to defer or whether to allow us to be heard in the April meeting. So I'm sure you want to help me talk, or you and Matt will be talking about that moving forward. Okay, and yeah, it's just, that's the echo process. The last point I have is the other variances that did not get approved, were they approved with or denied with prejudice, so they can't be brought forward for a certain time period? Is that
No, those 2 were denied without prejudice for lot size and lot width, so. You bring up a good point. Right now, the way the process is proposed, your proposed is on first reading for the text amendment for April. It would have to go second reading in May. You would have to still come back to this board for your development approval, even if the text amendment is approved, because they still have to do the development review. Then you'd be looking at applying for building permits. So one suggestion I have, to shorten the process, is if the town commission is willing to defer so that we could develop an ordinance to flip the process, we could have that ordinance before this board on its April meeting, then have it first reading in May at the town commission, and then concurrently perhaps consider them coming in for the initial review by this board.
Be fine.
To try to shorten that process,
Yeah,
knowing that
we'll
you
work
guys
with
have
that.
gone through,
So does the town council, so the final ordinance in a perfect world be April, P and Z, May, town council, and then would be June for the final town council
correct.
approval? But you're saying
Maybe if it's approved on first reading in May, then at the May P and Z meeting, you guys could come in for the P and Z review to then go to the Board of Adjustment, and then you'd be on the town commission, assuming they approve that process for approval.
so it'd be May, P and Z, June, Board of Adjustment. And then pending, the final approval, then we could maybe, does the town council take a summer break?
No.
No.
Okay, so then it'd be July for town council, and then we come back here for our development plan review and approval. Yeah, obviously it's a lot, so I know you guys have to chew, or just you guys are making recommendations this morning. And I know town attorney and my staff and my folks will have to figure out the legal sides of how that will work. I've talked to the client about the deferral and how they feel about that. And most towns, if you want to be heard, they allow you to be heard, but the writing, but you don't, the Ray Charles can kind of see, we need to make sure we want to be successful. So
I think you had to imagine that when you went from 1 lot to 8 lots, that it would become a more complicated process.
But I must say, from what I heard, there were some thoughts about, Pappas bought this and he didn't do his due diligence, or kind of buyer beware. And so I do think it's important that we show that there are other lots that are impacted by this significantly. So it wasn't really an issue of when he bought it or In fact, by the way, he did do due diligence, but that's neither here nor there, but it wasn't really that he bought it or not. I think whoever owns these lots are gonna have to deal with this at some point. And I think the town's gonna have to work on something to deal with this as well. And that's not just our lot, I think that's 8+ lots.
Okay, thank you.
Thank you. You've been very helpful.
Thank you very
Yeah.
much.
All right, so the
So we
motion.
had a motion.
You
Did
said-
we have the motion as Christie kind of amended it?
Yes.
Okay, I second.
So a motion to defer to the town commission for first reading with direction to the town attorney to draft an ordinance to flip the process for these properties in this area.
Excellent.
Yes.
Okay.
I
Agreed?
Second, all in favor?
Aye.
Aye.
Thank you,
Okay,
Christie.
Thank you.
Wisdom of Solomon.
Yeah, okay. What else have we got? Surpass?
Yeah, we gotta adjourn this meeting and open
Okay.
that meeting.
All right. Make a motion to adjourn?
I make that motion.
Second.
All in favor?
Aye.
Aye. Okay. Help us in. Yeah? Certainly. Not my specialty. Rick here special. Go ahead. Sorry, Lynn, you want to help us here or?
We need to open the meeting?
Yeah,
Oh,
we have to
okay.
open it as a separate meeting.
Okay, I call to order
This shouldn't take long.
the planning and zoning meeting of
The infrastructure surtax committee.
first.
Where did you get that from? With your organization.
Yeah, you've got the same thing in front of you.
Is that for,
For Surtax.
okay. To discuss the infrastructure surtax citizen oversight committee meeting agenda. Okay. Call to order.
Member Hutchins,
Here.
Vice Chair Carey,
Here?
Chair Marsh,
Here. Okay,
I move to approve the minutes from our last meeting at Chair. March.
January 24th.
January 24, 2022.
Second.
all in favor?
Aye.
Aye. Approved report.
I think the town manager gives a report.
Yes, Chairman Marsh, you have in your packets a copy of the annual report that will be presented to the town commission if you approve it at their April meeting, showing that in FY '22, the town brought in $159,372.17, bringing our total revenue from the surtax, local penny sales tax, of $774,662.57. There have to date been no expenditures out of this, and the balance in the fund is the $774,662.57. While it is not the committee's responsibility to identify how the surtax money is spent, that belongs to the town commission. They invite input based on that, and the committee has been designated for the next fiscal year, which begins on October 1, 2023. Eligible projects would be construction of a seawall at the end of Hudson, which has been on the list for several years, to mitigate flooding on that street, potable water infrastructure upgrades that would be including using some of this water potentially for the projects that we're doing with ARPA if we need additional funding. Drainage infrastructure projects throughout town, which has been on there, and we've also added septic to sewer conversion to this list this year. That is the only change from the report that has been submitted the past couple of years. The committee may also recommend to not spend any of the funds at this time and continue to accumulate the funds across many years to spend on a larger project, such as that potential septic to sewer. The town commission voted a couple of years ago to earmark all of the infrastructure to be received over a 10-year period for that septic to sewer conversion. At this point, we're at 6 years into that 10-year. So if that is the committee's recommendation at this point, we will present this committee or this report to the commission at the April meeting.
Okay, we didn't discuss this in the workshop in much detail, did we?
No, we didn't.
Okay. Thanks. All right. I haven't been following the sewer situation, but what is going
I
on?
know it's expensive.
It is
All the money that we
That's the only
can,
one that catches my eye.
the only thing that, all the money we can accumulate for it is good for the town,
Yeah.
so.
The original, is my understanding, the original estimate in 2019, 2020 was that the project would cost about $30 million. Any money that we can set aside, we can use obviously towards things like preliminary design engineering for that project, as well as the city's match towards any grant funding, which would be obviously why we'd be putting away 10 years of this preliminary funding for that. At this point in time, I do know there are some challenges with the package plant at Crown Colony. One of their injection wells has failed, and they are having some challenges with other vegetation infiltrating the package plant, and they are concerned that it may have significant problems sooner rather than later, which may force the town to begin the conversion process sooner, as that package plant feeds Crown Colony, the Ocean Ridge Yacht Club, and Colonial Ridge.
Well, that's good to know. Phew.
Do you think that the state will kick in any money for this septic to sewer? Because it seems I've been to one or two meetings and I didn't get a feeling that we're gonna be able to get much because we're affluent.
There is money out there, and there are ways to go about it. Palm Beach County tends to be more of a blue county than a red county. So if we are going to go after legislative earmarks, we are going to need to find someone who is well connected from a Republican standpoint to help us go after that, as it does take someone with those connections in Tallahassee to help make the case. But there are affluent communities that have received state funding, the Village of Gulf, Lantana, to name a couple that have recently received state earmarks for septic to sewer issues. Same with federal earmarks. There are federal earmarks for this that you can get in terms of earmarks as well as grant funding. But in order to do that, you have to put up matching funds to get the grant funds, and you have to be what they consider shovel ready. Shovel ready means you have to have the design engineering, at least the preliminary design engineering, done when you submit the grant application. At this point, we are not at that stage. We have not done any of the preliminary engineering for a septic to sewer conversion. We don't have hard preliminary cost estimates, just very soft cost estimates. And without those numbers and without a actual preliminary agreement with a wastewater treatment facility to provide the services once we do have a sewer system, again, we're sort of dead in the water. So we need to move things along to a next step before we can start truly applying for federal and state funding, then grant fundings for a septic to sewer project.
I thought we engaged some kind of lobbyist to do that.
We budgeted $20,000 for a lobbyist, but that is not going to,
2 phone calls.
that's not going to go very far.
Right.
And I was not able to find someone that
Fits the budget.
Yes, that fit our budgets at this point. I think our best plan of attack would be to team up with other communities and combine our resources for a lobbyist. And again, we have a grant writer, but without the preliminary design engineering for these projects, he can't write the grants for us because he needs the backup paperwork to submit with the grant applications.
Does anybody have any idea how much it would cost to get that plan?
I've done,
Would it be less than $775,000?
would it be less than? It's gonna depend on the scope, whether we wanna break the project down into phases. If we break septic to sewer down into multiple phases, the preliminary design engineering may be less than that, but, if we do the preliminary design engineering for the entire project so that we can break the construction down into phasing, it's probably gonna be close to $1 million. Just because of the complexity of us being a barrier island, making sure that we have the connections, as well as negotiating with someone to take our wastewater.
It would seem to me that maybe our town commission might consider getting the ball rolling instead of saying, well, we still have 4 more years to go. Let's spend some money because it's inevitable. We have to do something.
Does anybody have looked at doing like Gulfstream did, a partial for the areas that are more affected by not having a septic system? They did a section of town. Is there any steps to do that?
Normally what you would do is you would phase the town. But again, that comes down to the first step in that is deciding and negotiating who's gonna take our wastewater.
Boynton can't take anymore, right?
That I don't know. With the amount of development they have going on, they're probably gonna say no, because if they do, then they're gonna ask us to pay for any expansions to their wastewater plant.
Now, in the Florida Keys, DEP came in and said they mandated some areas to have to do. What's the thoughts about us getting a mandate? Do you think that's?
I think it's coming. It just hasn't hit us yet. And I think once a mandate hits, then we're behind the ball and it becomes that much more expensive because then you're on a clock and you have no choice. It's better to do it voluntarily than under a consent order.
Yeah.
Okay.
All right, well, let's keep that front and center, I guess.
Yeah. I like saving the money for
Yeah.
septic to sewer.
Yeah. I think that's everybody's feeling.
Okay.
All right.
All right.
We need a motion here. Motion to accept the Office of Town Manager's report and have it presented to the Town Commission.
Second.
All in favor?
Aye.
Aye. Thank you, Lynn.
Thank you. Good explanation, Lynn.
All right, now we can adjourn. Second.
Okay, so there's an adjournment on that.
Seconded.
All in favor? Aye.
Aye.
Thank you all.
Thank you. Nice job.
9:15 all morning.